భాగ్యంగా నేను భావిస్తున్నాను. ఎందుకంటే ఈ వ్యక్తి హైదరాబాదే కాదు ఎన్నో ప్రాంతాల్లో పనిచేసి ఇక్కడున్న ల్యాండ్ రిజిస్ట్రేషన్స్ కోసము, ఇక్కడున్న రియల్ ఎస్టేట్ రంగం కోసం ఎంతో కూడా వారు పాటుపడిన వ్యక్తి కాబట్టి ఇట్ ఈస్ మై ఆనర్ అండ్ ప్రివిలేజ్ టు ఇంట్రడ్యూస్ శ్రీ నవీన్ మిట్టల్ జీ. Shri Naveen Mittal belongs to the 1996 batch of the Indian Administrative Services and allotted to the Telangana cadre. He stood All India Third in Civil Services Examination in 1995. He is a B.Tech in Computer Science and Engineering from the prestigious IIT Delhi. In his 28 long administrative years career, he has held diverse posts like Commissioner of Visakhapatnam Municipal Corporation, Collector of Krishna and Hyderabad districts, Special Commissioner in Greater Hyderabad Municipal Corporation, Commissioner of Information and Public Relations, Secretary of Finance and later Municipal Administration and Urban Development, Commissioner of Higher and Technical Education in the state, and made his mark in reforming and re-engineering systems and processes wherever he has worked. Shri Naveen Mittal is presently holding the post of Chief Commissioner of Land Administration as well as Principal Secretary to Government in the Revenue Department. In his tenure of last 2 years, he has actively worked on streamlining Dharani, the government project for digitalization of land records throughout the Telangana state, and bringing in the new Bhu Bharati Act. Sir, your services to this particular state and also the Telugu states is very commendable. Thank you for joining us here today, sir. I now request sir to please come onto the dais and speak about Bhu Bharati. It is my privilege to welcome Mr. Naveen Mittal, IAS Principal Secretary, Revenue Department, onto the dais.
Good morning to all of you. First of all, I must thank both Raj News as well as the organizers, which are Naredco and HRA, and also all the sponsors for organizing this, I must say, one of the biggest real estate summits I've seen in Hyderabad in last few years. I mean, the kind of presence which is there is really, really remarkable to see. And I'm sure that you will all be benefited by the discussions, the presentations which are there throughout the day. I'm going to talk to you about the new Bhu Bharati Act, which has been passed by the legislature of Telangana and also received the assent of the Honorable Governor very recently. And we are in the process of notifying the date from which it will come into force. Can I have the presentation? Yeah. So, to give you a brief background to it, this new act of Bhu Bharati is basically brought in by the government of Telangana in order to streamline the land administration system and land records and ensure that the digitization of land records is proper and smooth and helps not just the landowners and people who are interested in buying and holding the land, but also the real estate sector in general. It signifies a very crucial shift in digitization of land governance. We had this Dharani Act in the past which came in 2020, but there were a lot of problems in terms of, one, the structure of the act itself, and also in terms of the process which was followed in digitization of land records, which resulted in lot of issues which we have been trying to resolve. But with the introduction of the new Bhubarti Act, we expect that those issues and those problems will be done away with, because we have now got the experience of almost 4.5 years of the implementation of Dharani. Now, it has basically three broad components. One is strengthening of administration, two is leveraging technology, and third is the legal backing. Only if all these three components come together, you have an efficient land record management system. To give you a brief background of the little bit of history of land records and the record of rights in land, we've had 3 acts in the state of Telangana, or the Telangana region of the erstwhile state of Andhra Pradesh, the United State of Andhra Pradesh. The first one was in 1948, after India became independent and Hyderabad state was merged with the Indian Union. We had this first act which came in 1948. That was one of the first acts, not just in this state, but also anywhere in the country. And it really resulted in lot of, I would say, formalization of land records. Many of you who've actually experienced the land records in Telangana, you would know of this 1954-55 Khasra Pani. Now that Khasra Pani was an outcome of the 1948 Act. And till today, that Khasra Pani is almost, the entry in Khasra Pani is deemed to be a title based on many of the judgments of Honorable Supreme Court. That is, it is as close to title as possible if the entry is there in Khasra Pani. And you can then understand the significance of the Khasra Pani. And then it was followed by 3 years land records, which was called Se Sala Pani. Many people misunderstand the word Se as Che Sala, but it is not Che Sala, it is Hindi Che. It is Se Sala, which is Persian Se. Se in Persian means 3. So that's why Se Sala means a 3-year Pahani. That's why we had this 55 to 58 Pahani, 59 to 61 Pahani, and then first followed by an annual Pahani. So that is how it all began. Then we had an annual Pahani. So that is how it was our Passbook and Titling Act, Title Deed Act, which was 1971. And that was, I would say, a very major effort in ensuring systematization of land records, because that time we had 2 regions. One is the Andhra region and the Telangana region, and it tried to bring in the best of the 2 regions and have this. And one of the major contribution of that was to introduce the Pattadar Passbook. So those of you who own land or who have transacted in land, you would see that most of the farmers will have this white cover Pattadar Passbook and also a title deed. So that was actually under that 1971 Act, and it was so strong that it stood nearly 50 years before 2020 Dharani Act was brought in. Now the aim of Dharani Act was to introduce technology into land record management. But then there were some very fundamental issues with the Act. I will give you some of those details which are now being corrected by the Bhubarti Act. And also the implementation of that happened in a way that the software which was used for Dharani was not properly tested, and then it became like an exercise of updating it as the problems arise. And that's why we've seen so many issues relating to the implementation of Dharani at the ground level. Now, lot of hard work has gone into the preparation of Bhubarti Act. The reason I'm telling you is just to make you familiar with a little bit background before we come into the features of this act. And to make this act, not just the 3 past attempts of ROR in the state were also taken into account, but we also looked at nearly 19 other states' ROR acts. So we try to bring in the best of what is there in other states and also in the 3 previous acts which are there. Because each had something good and something which was not in tune with the times. So it was put in the public domain on the 1st of July after the Honorable Revenue Minister made a statement on the floor of the House that this bill is being put in public domain, and we put it through almost like a month-long public consultation exercise. So much so that in every district, we organized a workshop sector and also from the legal fraternity and the experts and retired officials. It was a plethora of suggestions which we got, and some of them really, really good suggestions which were taken into account to bring in the final draft, which got approved by the Assembly and the Council in the month of December, on 18 December, and it has received the assent of the Honorable Governor of Telangana and notified on 4th of January of this month. We are still working out the date on which it will come into force, because there is some preparatory work which is required to ensure that the platform works smoothly in sync with the Act. So we expect that to happen very, very shortly. Maybe in next few weeks, it will come into force. Now, just to give you a few salient features of this, this Act, as I mentioned, is basically prepared with the background of the issues which we were facing during Dharni. You know, a lot of suggestions also came from the real estate industry also. In fact, I remember when I took charge as the Chief Commissioner Land Administration, I got delegations from almost all the major associations, including NAREDCO. I think twice NAREDCO has come, and 3 times. They've come and met me and also given gist of the problems which they were facing. So parallelly, we were trying to improve on Dharni, so much so that if I can give you the quantum of work which has happened in streamlining the Dharni system, more than 200 software improvements have been done in last 2 years. You can imagine the kind of quantum of work which has gone in. I mean, to make 1 or 2 changes in the software requires so much, but there's nearly more than 200 plus changes which have been done in the software to ensure that it responds to the issues which public has. Now, in the Bhubharti Act, as I mentioned, there are also a lot of legal issues which were there in the Dharni Act which have been trying to be rectified. And I'll just give you a little brief of it. So, the 3 major sections which are there in Dharni, this Bhubharti Act, are section 5, 7, and 8. Now, section 5 basically deals with all the sale-related or gift-related aspects of land transfer. That is, you sell the land, or you gift the land, or you partition, or you mortgage, or you exchange. When that is happening, there is already an entry in the land record in favor of the landowner. So the landowner goes to the sub-registrar, which is the Tehsildar as of under this Act. And there's also a possibility that Deputy Tehsildar can also be given that power, because sometimes Tehsildar is not there in the office. And when the landowner, that is the seller, and the buyer, they go, the transaction happens through the Aadhaar authentication of both the seller and the buyer, and the instantaneous transfer of that land takes place from one account to the other, and instantaneous mutation and passbook generation happens. So that happens under section 5. The second section which is there is section 7, which deals with the succession related issues. In fact, one of the major shortcomings of the Dharni Act was that there is no provision for any verification of whether all the legal hires have come or not. So in fact, I have personally come across a few cases where, let's say, the landowner dies and he or she had 5 legal hires. Now only 3 will come with an inter se family settlement deed. ignoring the two others, they don't even tell that they are going to get this mutated. Just 3 will come to the sub-registrar, that is the Tahsildar, and get that mutated in favor of the 3. Now later on, when the 2 other people come to know, they really have no recourse to that, and that is the beginning of a dispute in that land transfer. And more often than not, those 3 people will actually sell that land or transfer in the name of a third party also within a matter of a day or 2. And the buyer would not even know that there were 2 other people who were left out. So that was one of the major lacunas, because the act didn't provide any sort of a verification. Now under this new act, there is going to be a verification mechanism which will ensure that all the legal heirs are actually covered. And then only that succession happens. And the succession also, we have also given provision for other things also, which are again absent in the previous act, which is will, or whether a registered will or an unregistered will, and also other mechanisms through which that can happen. So that's one of the major improvements. Then the third section relating to this is section 8. Now this is a huge improvement compared to the Dharni Act, because the Dharni Act only provided for only through a court decree a mutation could happen. But there are multiple other ways in which mutation can happen, which could be, let's say, an ORC which is issued, or a 3080 certificate which is issued, or a 13B, 3080 under the Tenancy Act, or 13B under that regularization of Sada Bainama, or a sale certificate which is issued by some authority. Let's say an NCLT has sold the land, or some other entity has sold the land, or even when government has actually also alienated the land in favor of, let's say, a company or an entity or an individual. There was no, it's really surprising, but there was no real provision under the Dharni Act to do that kind of mutation. It was all left to an executive circular to do that. And many times that used to be challenged in the court, and the court used to question that since you don't have a legal authority, how are you doing it? Now this act brings all those possible mechanisms for such transfer under the ambit of section 8, and that will be done at the level of RDO. In fact, in the previous avatar, that is Dharni, all those changes were actually coming up to the level of collector because of the system and the circular on the basis of which this was done. So now it is going to be done at the RDO level, that is a revenue divisional level, a revenue divisional officer level. So for 5 and 7, Tahsildar is the competent authority. 5 can also be delegated to Deputy Tahsildar, and 8 is going to be the RDO. So this is the major overall architecture of this act. Another improvement which has been done is this whole gamut of how the initial ROR is prepared and how the ROR is corrected. That is, a record of rights is prepared and corrected. Now, in the Dharni Act, there was a provision for preparation of ROR. That's how the land records came up through the LRUP program. But there was no provision under the Act for how do you correct the entry. Many of you would have heard these modules, TM33, TM31, so many other modules which were there. All those modules did not really have a legal authority. They were all based on an executive circular from the Chief Commissioner Land Administration, because CCL has the power of the Board of the Revenue. So based on only the circular, all those changes were happening, but there was no legislative backing to it. And that's why when sometimes it was questioned in the court, it actually was very difficult for the person to prove that yes, this change has happened through a legally backed mechanism. And that resulted in a lot of increase of litigation in this area. Now, under the Bhubharti Act, section 4.5 and 4.6 will provide for that legal backing. 4.5 is for correction of an existing entry, and 4.6 is for a missing entry. And these two sections now give that provision under which a competent authority can be defined by the government and that competent authority will have power to either add an entry or to correct an entry. And that ensures that legal safeguard comes in. Another important issue which in fact the industry knows and industry used to always complain about was the absence of an appeal or a revision mechanism under the Dharni Act. There was no appeal or no revision mechanism. If you have a problem with whatever has happened, the only recourse is to go to a civil court. Now, the Bharati Act provides for a very, very strong two-tier appeal mechanism, first appeal and a second appeal. First appeal will be to the next competent authority. Like if the order is by a Tahsildar, the first appeal is to RDO and second appeal is to collector. There are certain sections where RDO is the original authority, then the first appeal will be to collector and second appeal will be to land tribunal. So that ensures that in a summary way, those problems can be dealt with rather than a very, very lengthy and formal process of a civil court, because many of these issues actually can be addressed through revenue department based appeal mechanism. And this is what this act also tries to bring in. There's also a revision mechanism if there is some land of wherein government interest is involved and that is actually transferred illegally or unauthorizedly, then the CCLA will have power for revision to correct that. Now there are a lot of futuristic provisions also which are there in the act. As I mentioned, this act has been prepared by looking at all the other state acts, our previous 3 acts, the implementation of Dharni, and also in which direction the land record management system is actually heading. So there is something called Bhudar, which is now being talked about in the country, which is like every person is having an Aadhaar number. Every land parcel will also have a Bhudar number. So that if you just enter that, like the Aadhaar number, we use it. Similarly, if you enter that unique number, you actually get all the details, the location, survey number, village, mandal, district, state, that information can be done. So you can just kind of communicate with that single Bhudar ID. Now, again, this act provides for a legal background, backing for that. And there's a provision for a temporary Bhudar, which is a unique ID which will be given. And there's also a provision for permanent Bhudar, which is going to be based on the geo coordinates of the land. And that will ensure that there is a unique land correlation, which parcel it is and which ID it is. Another very important factor is that while doing registration, the Act provides for a survey or a subdivision map to be attached to the registration document. Now this is something which is being done in our neighboring state of Karnataka for quite some time. In fact, if I remember correctly, Karnataka is doing it from almost like 2008-9 under their Bhumi project. So what has happened is, in last 15-16 years, because a subdivision or a survey map is attached to the registration document, their land records have been, the spatial land records have also been improved. So much so that today, nearly 90 to 95% of their land record is now having a proper authenticated latest map. Whereas we have a lot of issue because in our state, somehow historically, subdivisions has not happened. Our subdivisions have happened only in the register, but not in the map. And this will ensure that there's a continuation of that subdivision process as and when the land is transacted. Again, the last point which I've mentioned there is again something which is very, very futuristic, and in fact we are one of the first states in the country to talk about this. is the record of rights in non-agricultural land and also Gram Kantam and Abadi land. And the Act provides a provision for it. Of course, it will come into the force from which government feels that the system is ready to implement it. But there is a legal now provision in the Act itself to do that. And this will ensure that even non-agricultural lands also, there is some element of ROR which happens. Now, the reason why it is very important is that historically, non-agricultural lands were not under the purview of the ROR. And the reason for that is, if you look at the history of land records, we started from a time when the land record system was more about collection of land revenue from the land. Because at that time the income tax or no present GST or sales tax was not a very important component of government income. Most of the income used to come from land. So the state, that is the government, was very much interested only in from whom do you collect the land revenue. So if you see most of the records are basically a record of assessment of land revenue. It has not traditionally been a record of rights or the title. And that's why we've kind of missed the maintenance of non-agricultural land record historically, not just in our state, but in most other states of the country also. And this is something now which is provided under the Act. I'll just quickly go through. This Act also provides for linkage of the online record with the village account also. You know, traditionally we had this Pahani, but somehow after the Dharni came in, the Pahani stopped. Now that Pahani or the modified Pahani is going to be derived from the online system, so that there is some annual record which is maintained at the village level or in some form. There's also a provision for going to civil court also under the Act if you are not happy with any entry, and there is an aspect of title in it. One can actually go to civil court. One also important feature of this is it also provides for limited regularization of Sada Bainama. Many of you would be aware that there was large-scale collection of Sada Bainama applications just at the time when Dharni Act was coming into force. It came into force on 29th October 2020. So sometime from, if I'm not wrong, about 11th or 12th of October till about 9th of November, there was a provision to submit Sada Bainama transactions online. And we got nearly about 9.5 lakh such applications all over the state. But then it was stayed by the High Court saying that the Dharni Act didn't provide for that provision, either for clearance of the pending applications on the date at which came into force, and also for collection of application after it came into force. So because of that, this was stayed. So this Act provides for a limited provision of clearing those applications, that is, which are received during that time and which are before 2nd June 2014, that is the state came into force. And also there's an aspect of there must be at least 12 years of possession which must be proved to get that done. So that's why this is a safeguard, so that it should not be misused. So since now the Act has been notified, we are in the process of forming rules under the Act. Again, this is something which was missing under the ROR Act of 2020. The rules were never notified. Even for the 71 Act, the rules came in 1989, so almost after a period of 18 years. And in last 4.5 years, the rules could not be prepared or notified, and